Ma'am, we are starting with the session.
Okay.
Good evening, everyone. I am Aryan Gupta, the host of today's session. I, on behalf of the whole Jus Corpus team, welcome you all in today's session on surrogacy laws. Before we delve into today's discussion, let me provide a brief introduction of Jus Corpus and the eminent guest speaker of the day. Jus Corpus is a body of legal professionals who have come together to bring various aspects and chains of laws under a single umbrella. Juice Corpus, an edtech platform set up in 2020, has a wide reach of over 600,000 clicks per month on an average basis on our website. The inspiration was derived from ever-growing need for law students. Juice Corpus has also incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries, named as the Juice Corpus Law Journal and the International Journal of Legal Research, Education and Social Sciences. Now turning our attention to the focal point. We are privileged to have Ms. Mohini Priya as our esteemed guest speaker for the day. Ms. Mohini Priya is a distinguished AOI at the Supreme Court of India, certified as a trained mediator by the Mediation and Conciliation Projects Committee, and empaneled with the Supreme Court Mediation Center. Graduating from the prestigious GLC Mumbai in 2009, she has consistently exhibited unparalleled dedication, expertise, and commitment to the legal profession. Her work spans a range of legal domains, including constitutional law, health, medico, and legal issues, service laws, media laws, intellectual property, civil and criminal litigation, and arbitration. She has recently achieved significant milestones, notably her involvement in a PIL representing a renowned IVF specialist, Dr. Arun in Chennai. The litigation challenges the restrictive nature of the Surrogacy Regulation Act 2021 and the Assisted Reproductive Techniques Act 2021 before the Honorable Supreme Court. This underscores her commitment to address contemporary legal issues and assisting childless couples facing infertility. Additionally, she played a crucial role in urging the central government to eliminate the domicile and NOC requirement for cadaver organ transplant restrictions. This was achieved through a PIL filed before the Supreme Court on behalf of the Gift of Life Adventure Foundation, a prominent NGO dedicated to organ transplant awareness. In a recent PIL titled Anirudh Naram versus Union of India, she represented the petitioner before the Honorable Supreme Court and she advocated for the regulation of private coaching institutes in the light of suicides in Kota. Following discussions with concerned department secretaries, the central government passed guidelines for the regulation and registration of private institutes in India. These successful efforts demonstrate her role in shaping legal policy in the country. She is also waiting for the regulation of fast-growing field of education technology, which is under consideration by Delhi High Court. She is a prolific writer, having authored several published articles on topics of legal and social relevance, including surrogacy laws, fashion laws, environmental law, SC/ST Act, marital rape, juvenile justice laws. Her contribution has not gone unnoticed, as evidenced by the recent achievement of winning the prestigious Lex Faction Global Awards 2023 held in Singapore. She is also empaneled with the state of Jharkhand and the University of Delhi. She is on the advisory board for organizations such as Juice Corpus. Beyond her legal practice, she has shared knowledge through guest lectures, discussions at prestigious colleges like GNLU, and has been a sought-after judge for national and international moot court competitions. In the recent Kolkata rape and murder case, the suo motu matter of Ajika rape and murder case, she is a part of the team of lawyers representing the Federation of Association of Medical Consultants of India before the Honorable Supreme Court of India. So over to you, ma'am, and hope you have an insightful session today. Thank you.
Thank you. Thank you very much for the very, very elaborate introduction. And I think we should right away move to the main topic, which is the Surrogacy Act. So let us first start with what is surrogacy as per the Act, why it is so important in today's time. So as per the Surrogacy Regulation Act, which was passed in December 2021 and enforced in January 2022, surrogacy is defined as a practice whereby one woman agrees to give birth to a child for an intending couple with the intention of handing over the child to the intending couple. So this is how the Surrogacy Act defines surrogacy. Now, why surrogacy is so important is infertility now has been declared as a global health issue by the World Health Organization. And 1 in every 6 individuals worldwide is suffering from one or the other form of infertility. On an average in India, there are 1 lakh IVF cycles. Out of those 1 lakh IVF cycles, 1% of the people who have extremely exceptional cases go for surrogacy, which means around 400 to 500 babies born out of surrogacy, which was before the regulation was enforced. Now, why it is very important to discuss about the recent regulations governing surrogacy law is that in the current scenario where infertility is a global health issue, the acts surrounding surrogacy and IVF, which are important forms of assisted reproductive technologies, need to be enabling in nature, in the sense that they should help the beneficiaries under the act. Who are the beneficiaries under the act? It is the parents, the intending couple, the surrogate mother, of course, and the child born out of surrogacy. So later, first I'll be taking you through the scheme of the Surrogacy Act, as in what kind of surrogacy is allowed, what are the conditions for availing surrogacy, and after that we will go through the constitutional issues and its impact as a beneficial legislation. So starting with surrogacy and its types, there are 2 types of surrogacy, traditional and gestational. Traditional surrogacy used to be followed earlier, where there was actually sexual intercourse leading to impregnation of a third woman, which is known as a surrogate mother. Now, that is not in practice. What is allowed under the Surrogacy Regulation Act is gestational surrogacy, which is surrogacy by means of IVF, in the sense that the gametes are first outside, they are fertilized outside the human body, and then the embryo is transferred into the womb of a third party, which is a surrogate mother, who can or cannot be related to the intending couple. So there is no such bar. Initially there was some confusion regarding this, whether the surrogate mother has to be a relative of the intending couple. But the government has come up with the clarification that the surrogate mother just needs to be a woman who's willing to act as such, and she should fall under the prescriptions prescribed under the Surrogacy Act, but there is no such requirement of her being related to the intending couple. So any willing woman can be a surrogate mother, as long as she's doing it altruistically, which is without any commercial motive or without any profit-making motive. So in that sense, there are 2 other forms of surrogacy, which is altruistic and commercial. In India, the Surrogacy Regulation Act totally prohibits commercial surrogacy and allows surrogacy only in the altruistic form. So Section 4, subsection 2 of the Surrogacy Act, if I may read, says that no surrogacy or surrogacy procedure shall be conducted, undertaken, performed, or availed of, except for the following purposes, namely, number 1, when it is only for altruistic surrogacy purposes, and number 2, when it is not for commercial purposes or for commercialization of surrogacy or surrogacy procedures. So this was the whole point of bringing about a regulation in the field of surrogacy, because there was rampant commercialization at one point of time, and the consequent exploitation of surrogate mothers. There were many reported cases. So that is why there was a need for a regulation. But now what has happened is, instead of regulating surrogacy in a positive manner, the government has ended up making it extremely restrictive, violating the reproductive rights of intending couple as well as the rights of surrogate mothers. We'll come to that later. Now let us come to the definition of altruistic surrogacy and commercial surrogacy. So altruistic surrogacy means surrogacy in which no charges, expenses, fees, remuneration, or monetary incentive of whatever nature, except the medical expenses and such other prescribed expenses incurred on surrogate mother and the insurance coverage for the surrogate mother, are given to the surrogate mother or her dependents or her representatives. So this is provided under Section 2B of the Surrogacy Regulation Act. Then we come to Section 2G, which defines commercial surrogacy, which is the exact opposite of altruistic surrogacy, which means commercialization of surrogacy services or procedures or its component services or component procedures, including selling or buying of human embryo, trading in the sale or purchase of human embryo or gamete, or selling or buying or trading the services of surrogate motherhood by giving payment, reward, benefit, fees, remuneration, or monetary incentive in cash or kind to the surrogate mother or her dependents or her representative, except the medical expenses and such other prescribed expenses incurred on the surrogate mother, as we had discussed earlier. So now if we briefly, we can skip the historical background of surrogacy in India. We can come to that later probably, because that's not very relevant as of now. We'll straight away go to the objectives of the Surrogacy Regulation Act, and then we will try to correlate it with the provisions and how the provisions do not really fall within the objectives of the Act. So the main objectives of Surrogacy Act was to constitute a National Assisted Reproductive Technology and Surrogacy Board, to constitute State Assisted Reproductive Technology and Surrogacy Board, and to appoint appropriate authorities for regulation of the practice and process of surrogacy and for other related matters. So now the objective of the Act nowhere states that there is a complete ban on commercial surrogacy, or that the Act was brought about with the objective of banning commercial surrogacy, allowing only altruistic surrogacy. It only states that it is brought about with the object to regulate the practice and process of surrogacy. Now let us see what an intending couple means as per the Act. So an intending couple means a couple who has a medical indication necessitating gestational surrogacy and who intend to become parents through surrogacy. Now, what is the essential prerequisite of a couple? First of all, surrogacy can only be availed of by a married couple or a single woman who has been married but divorced or widowed. So a single unmarried woman, a single married man, same-sex couples, live-in couples are completely excluded from the purview of the Act. So now surrogacy is only available to married couples in India. Apart from that, they need to have a medical condition which is prescribed under Rule 14 of the surrogacy rules, which would include the absence of uterus, recurrent miscarriages, recurrent IVF failures, or any other condition which would make it life-threatening for them to go for surrogacy. Apart from that, there is also an age restriction on the intending couple. So the woman in an intending couple has to be between 23 to 50 years of age, and the man has to be between 26 to 55 years of age. So these are the prerequisites or the essential conditions for a married couple to go for surrogacy in India. Now let's see what a surrogate mother means under the Act. A surrogate mother, which is defined under Section 4(3)(b) of the Surrogacy Act, means a woman who agrees to bear a child, the child who is genetically related to the intending couple or to the intending woman. By intending woman, we would mean a widow or the divorcee, as we had earlier discussed, through surrogacy from the implantation of embryo in her womb and fulfills the conditions as provided in subclause 4(3)(b) of the Surrogacy Act. So the definition of surrogate mother says that the child that she's bearing has to be genetically related to either of the intending couple. In fact, there was some confusion regarding this definition of surrogate mother, because of which there was a notification issued in March 2023, which clarified the position, stating that donor eggs cannot be used for surrogacy. Now, that notification was challenged before the Supreme Court, and ultimately the court and even the central government realized that such a ban would totally negate the purpose of surrogacy, and hence an amendment was brought about in 2024 stating that the child has to have gametes from either of the intending parents, at least one of the intending parents. So donor gametes are now allowed after the amendment. Again, we go to the eligibility criteria for intending couples. So the intending couple must be in possession of a certificate of essentiality issued by the appropriate authority. Now, what the certificate of essentiality would include? This is first a certificate of medical indication in favor of either or both members of the intending couple or intending woman, necessitating gestational surrogacy from a district medical board, which refers to the conditions prescribed in Rule 14 of the rules that I had discussed. Second is an order concerning parentage and custody of the child to be born through surrogacy, which must have been passed by a court of the magistrate of first class or above. So this parentage order is absolutely essential for a couple to go for surrogacy even before they start the process of surrogacy. So this is primarily to safeguard the interest of the child to be born through surrogacy and prevent any sort of abandonment or such malpractices. Then there needs to be an insurance coverage for a period of 36 months in favor of the surrogate mother, covering postpartum delivery complications. And third is the certificate of eligibility for the intending couple, which would state that the intending couple are married and between 23 to 50 years in case of female and 26 to 55 in case of a male. And the second condition is that the intending couple have not had any surviving healthy child, biologically or through adoption or through surrogacy earlier, which means that the Surrogacy Act also bans a couple, a married couple who has one healthy surviving child to have their second child through surrogacy, which means it has completely overlooked the cases of secondary infertility, which is in fact more prevalent in India than primary infertility, considering the late age of marriage and environmental conditions, etc. So this provision of not allowing a second child through surrogacy, if there is a healthy surviving first child, this is also under challenge before the Supreme Court of India. And the center is considering this issue. Now we will go on the eligibility criteria for surrogate mothers. So the Act says that no woman other than an ever married woman having a child of her own and between the age of 25 to 35 years on the day of implantation shall be a surrogate mother. So this is a prerequisite. She has to be a married woman between 25 to 35 years of age, and she has to have a child of her own. A willing woman shall act as a surrogate mother and be permitted to undergo surrogacy procedures. So as I had already discussed, that a surrogate mother need not be related to the intending couple, but she has to be a consenting woman, a willing woman. So she cannot be coerced to go into surrogacy. No woman shall act as a surrogate mother by providing her own gametes. So as discussed earlier, the child born out of surrogacy has to be genetically related to the intending couple, and the child does not have to have the same gametes as the surrogate mother. So which was earlier a practice under traditional surrogacy. Under gestational surrogacy, the same has been ruled out. The surrogate mother cannot provide her gametes to the child. No woman shall act as a surrogate mother more than once in her lifetime. This is also another provision that has been brought into force to prevent womb renting, which was a practice in the 2000s, which led to the coming into force of this Surrogacy Regulation Act. So now, legally, a surrogate mother can only act as such once in her lifetime. A certificate of medical and psychological fitness for the surrogacy and surrogacy procedures from a registered medical practitioner. So these are the eligibility criteria for a surrogate mother. So now what are the rights and responsibilities of the surrogate mother? The rights are medical and insurance coverage, and she has a right to withdraw from surrogacy before embryo plantation. For the intending couple, they have a right to legal parenthood from the moment of birth of the child and assurance of the surrogate mother's informed consent and the rights of the child born out of surrogacy. The child has a right to be recognized as the biological child of the intended parents, and they have right to inheritance and other legal protections. So now, as discussed, what has been prohibited is commercial surrogacy and all forms of its advertisements. Surrogacy for the purpose of producing children for sale, prostitution, or any other form of exploitation. Exploitation of the surrogate mother, abandonment of the child born out of surrogacy, sex selection via surrogacy, abortion of the surrogate fetus except on prescribed terms, and surrogacy practices by unregistered clinics. So these are the prohibited practices under the Act. Now, this was the general overview of the Act. Now we can have a discussion on commercial surrogacy, the ban on commercial surrogacy, and why altruism cannot work in India. So as discussed earlier, the Surrogacy Regulation Act allows only altruistic surrogacy and expressly prohibits any form of commercialization of surrogacy practices in India. Now, legally and constitutionally speaking, such a complete ban on commercial surrogacy denudes women of their right to privacy, bodily autonomy, which forms an integral part of the right to life guaranteed under Article 21 of the Constitution, as also they fall foul of the test of reasonableness and proportionality under Article 14 of the Constitution. So these are the constitutional impediments. Other than that, not paying a woman for 9 months gestation period to bear a child for another couple and not giving her a reasonable compensation for the temporal separation from her own family, physical and emotional labor involved in carrying a baby in a womb, and the resulted loss of income also contravenes the provisions of Article 23 of the Constitution, which prohibits forced labor. Apart from that, a complete ban on commercial surrogacy would inevitably lead to emergence of underground markets in surrogacy. So the entire process, it's the entire purpose of the Surrogacy Act, which was to prevent commercialization of surrogacy and prevent exploitation of surrogate mother, will be negated if there is no reasonable compensation provided to surrogate mothers who are spending their time, energy, and actually helping other couple start a family of their own, which in itself is an act of altruism. And just because some amount of compensation is paid for the same would not make the act less altruistic. Now, here the angle of reproductive autonomy comes into play, which has been discussed, which has been categorically held by the Supreme Court in several of its judgments, starting from Shuchita Srivastava versus Chandigarh administration, which is 2009 9 SCC 1. And recently in the case of X versus State of Delhi, which is 2023 9 SCC 433, all these judgments have discussed the ambit of reproductive rights, and hence a complete ban on commercial surrogacy and the restrictions that have been placed by virtue of the Act as to the age of the woman, the lack of compensation to be paid out to a surrogate woman. These are all a violation of reproductive autonomy of a woman. Hence, the Act has to be tested on grounds of constitutionality as well. Now, these were the constitutional loopholes in the complete ban on commercial surrogacy. Now I'll come to the other segment, which is the upper age limit that has been provided in the Act. So the Surrogacy Act provides that a woman has to be 50 years of age and a man has to be 55 years of age if they want to avail. That is the maximum age limit that is provided for a man and a woman who are married to each other to avail of surrogacy. Now, I would also like to have an interactive session on this, and I would like to know your point of view on why having an upper age limit justified under the Act? Is it not justified? Should it be made mandatory? Should it be directory in nature and depend on the facts and circumstances of each case? And should also depend on the recommendation of medical board and of the doctor who's treating the patient, or there should be a blanket upper age limit for couples who want to avail of surrogacy, considering that in today's time the average age of marriage has increased. So usually people are getting married in the late 30s now, most of them, if not early 30s, late 30s. Then they want to plan a career, have stability in their life before they start planning for a child. So in such cases, the upper age limit of 50 and 55 reasonable in Indian conditions? What are the pros and cons? We shall discuss that in our interactive session. So the third issue that I would like to discuss is the ban on having a second child through surrogacy if the couple has a healthy surviving first child. So this is again a major issue because no other statute dealing with reproduction or adoption has any such ban on having a second child. India as a nation, we do not have a one-child policy. The Assisted Reproductive Technology Act, which is the sister act of the Surrogacy Act, and it deals with IVF and other procedures, does not impose any such restriction on having a second child through IVF. The Hindu Adoption and Maintenance Act, the Juvenile Justice Act, none of these acts have restriction on having a second child. So why is the Surrogacy Act making the act of surrogacy or surrogacy sort of a taboo, that if a couple has an existing child, they cannot have a second child through surrogacy? Because there are several cases of secondary infertility, which means that in the first pregnancy, you can have a normal delivery, but then later on, when you're trying to conceive a second child, you develop certain complications and you're unable to bear a child in the natural process. So how do we take those cases into account, which comprise the majority of cases? And why is surrogacy restricted to only to a very, very limited class of people? So this is a question that we should dwell upon. Third, I think this is the last topic that I would like to deal with, is that the Surrogacy Act is a beneficial legislation. Now, considering the restrictions that have been brought about by the Act, how is the Surrogacy Act when coming to the rescue of any of its beneficiaries? The beneficiaries being the intending couple, the surrogate mother, and the child born out of surrogacy. When it comes to the intending couple, the Surrogacy Act has made it extremely restrictive and can be availed of only by those couples who fall within an age bracket and who have a medical condition as prescribed under Rule 14 of the Act. So it is extremely, so it is restricted to only those married couples. Apart from that, single women have been completely excluded from the purview of the Act. Then when we come to the rights of the surrogate mother, which is another beneficiary under the Act. Surrogate mother, there is no compensation provided, no monetary compensation provided for a surrogate mother. She's expected to act as a surrogate mother, bear a child for 9 months without getting anything in return, apart from an insurance coverage of 36 months. So which in itself is a form of a forced labor. So obviously, it is not coming to the rescue of surrogate mother as well. And when it comes to the child born out of surrogacy, there are sufficient safeguards provided under the Act, which prevents the abandonment of a child born through surrogacy. And a child born through surrogacy is deemed to be a biological child of the intending parents. So, as far as the child is concerned, there is no scope of any form of exploitation left, and hence this restriction on having a second child through surrogacy is absolutely unreasonable. And in my opinion, it should be struck down. So that's about it. I think that is the gist of the Surrogacy Act that I would like to discuss today. And if any of you have any questions, then I'm open to a discussion right now.
Ma'am, we have a few questions that were submitted by the participants. So,
Yes, please.
Some of the first question that was asked to us is there a difference in the rights of child born through surrogacy as compared to a child born biologically?
No, there is no, right, born through surrogacy and an adopted child.
No, not adopted, like a normally born
Naturally,
child.
no. So the Surrogacy Act clearly lays down that a child born through surrogacy shall be deemed to be a biological child of the intending couple and have the same legal rights as a biological child. So there is no difference legally between a surrogate child, and that is why there is a requirement of a parental order before the childbirth.
Thank you, ma'am. The next question is what legal rights do surrogates have during pregnancy?
See, surrogates have a right to insurance for a period of 36 months. Other than that, she has a right to incur cost on medical expenses and other ancillary expenses. Now, the Act also says that she has a right to some prescribed expenses. Now, what these prescribed expenses are has not been laid down. So, ideally, the surrogate mother should have been paid for expenses for childbirth, a reasonable monetary compensation for bearing a child for 9 months. The compensation for, since the surrogate mother needs to have a child of her own, so the compensation for staying away from her child and maybe having some help for raising her own child. So these then there could be compensation for loss of work which she'll have to undertake as she is totally under medical care for 9 months. So these are the expenses that should have been considered, but they have not been laid down under the Act. So if the government decides to clearly lay down what are the other prescribed expenses that could be provided to a surrogate mother, I think the scenario could be much better than what it is right now. And there'll be less scope of exploitation, less scope of underground markets in surrogacy. Maybe the government can also fix an upper and lower limit for reasonable monetary compensation that has to be paid to a surrogate mother.
Thank you, ma'am. The next question is can a surrogate mother have a biological child of her own after the surrogacy?
Yes. There is no bar on that. She can definitely have a surrogate mother can have a biological child of her own. But after she delivers its surrogate baby. So no bar on that.
Thank you, ma'am. Ma'am, the next question is how will the recent judicial decisions in the MRTP Act affect the autonomy of an unborn child?
Sorry, I didn't get the question.
How will the recent judicial decisions in the MRTP Act affect the autonomy? Yes, ma'am. Affect the autonomy of an unborn child.
See, the recent judicial decisions on the MTP Act has more to do with reproductive autonomy of a woman. So there a very delicate balance has to be struck between the rights of the child, of an unborn child, and the rights of the reproductive rights of a woman. So here, now surrogacy is completely different. MTP's Act is about abortions and termination of pregnancy. So there, the rights of the woman who intends to terminate her pregnancy has to be balanced with the right of the unborn child, uh, which would depend on the facts and circumstances of each case. Although the Supreme Court of India has allowed medical termination up to 36 weeks, but now that totally depends on the facts and circumstances and on the opinion of the medical board. But as far as mm, surrogacy is concerned, I think the rights of the child are absolutely taken care of. And what we need to focus on here is the reproductive right of the surrogate mother and the intending couple.
Thank you, ma'am. And the next question is, how are the surrogacy laws in India? How do the surrogacy laws in India compare to international standards?
See, I would say commercial surrogacy is not allowed in many countries of the world. So as India, we are not the first ones to place a ban on commercial surrogacy, apart from some states of US, and then there's Georgia and Ukraine. These are the places where commercial surrogacy is allowed. But in many other countries like UK, Russia, any form of commercial surrogacy is completely banned. But India, we cannot really compare our laws with other laws, with the laws of other countries, because we are a unique nation now. We are extremely populous nation, and the number of infertile couples that would need surrogacy and IVF is huge in India as compared to other countries. Also, the laws, also the conditions of women here. Women in India are much more prone to exploitation, much more vulnerable than many developing countries of the world. So the laws have to be accordingly framed. So the law has to go with the societal construct, and hence, I think surrogacy laws in India need to be more enabling in nature, because by what they have done is while the intent of the government was to regulate the malpractices of commercial surrogacy and exploitation, they have placed unnecessary restrictions here on surrogate mothers, on intending couples, which has made it next to impossible for people to avail surrogacy in India, which once used to be a surrogacy hub of the world. So, in that case, there has to be sufficient safeguards in place, sufficient checks and balances, but that has to be balanced with the rights of the intending couple, so that the purpose of behind the passing of the act is not negated.
Thank you, ma'am. And the next question is, are there any proposed amendments or reforms in surrogacy laws in India?
See, the only amendment that has been recently brought about into 2024 was regarding the ban on use of donor eggs. So, as I had already discussed, there was a notification issued by the Health Ministry in March 2023, by which use of donor eggs for surrogacy was completely banned, disallowed. Now there has been an amendment in 2024 by which the law allows the use of donor gametes as long as one of the intending parents provides their gametes. So one gamete has to be from the intending parent, and one donor gamete is allowed now. That is the only amendment that has been brought about. Rest, there are many other issues which are pending before court. The issues being cases of intending couples who have frozen their embryos prior to the passing of the act. And now, by virtue of the restrictions placed under the act on age, on having a second child of surrogacy, they have been debarred from using those frozen gametes. So, in the lack of transitional provisions under the acts, how do the intending couples deal with that issue? What happens to the frozen gametes for those that have been frozen 5 or 6 years in advance? So that is one very important issue that needs to be dealt with by courts. Other than the upper age limit, the fixed upper age limit that is provided for a man and a woman of an intending couple under the Act, whether it can be directory or it needs to be mandatory. So there is only one amendment that is currently in force, but we are fighting for other causes as well, and hoping that something good will come out of it.
Absolutely, ma'am. Now the next question is: if the intending couple has a differently able child, the can they have another child through surrogacy?
Yes, yes, that is an exception that has been provided under the Surrogacy Act. So while a second child is not allowed if you have a healthy biological child or adopted child or through surrogacy, if you have a differently abled child, then you can go for a second child through surrogacy, provided you have a certification from the district medical board as regards the disability of the child.
But ma'am, doesn't this provision directly go against right to equality of a person with disability because it essentially treats
Certainly,
them like a
certainly.
second-class citizen?
Most definitely. So that is exactly what our argument is, that you are in fact not just against the rights of the child, but also against the basis of parenthood. So what you are trying to say is that couples who have a differently abled child would need another child to have a complete family, as opposed to couples who have a healthy surviving child. So there you are creating a differentiation between a healthy child and a differently able child. That's a major differentiation, and I think that's it is a completely arbitrary provision. It makes no sense.
Yes, ma'am. Yes. Ma'am, the last question we have is: are there any instances where the child was left with the surrogate mother rather than the intending couple?
Sorry, are there any examples?
Are there any instances, yes, ma'am, examples where the child was left with the surrogate mother rather than the intending couple?
See, there were cases like this before. There were some cases in which, because earlier the practice of gestational surrogacy was not by way of a regulations. So there were cases of who is the biological parent, and sometimes the surrogate mother would not agree to give the child to the intending couple, or the intending couple would just abandon the child. And if the couple was from a foreign country, they would just not come and take the child home if the child was born with a disability. So there were many such cases, because of which the act of surrogacy had to be regulated, and it's a very good thing that the regulation is in place, uh, because at least these uh, things are taken care of. But now we need to make sure that the beneficiaries under the act are actually benefited from surrogacy and assisted reproductive technology, and there are no unnecessary restrictions under the act.
Thank you, ma'am, for the insightful question answer round. That was all from our side. So, do you want to
Oh,
extend a few closing words? So, in closing, we extend our heartfelt gratitude to Mohini ma'am for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. Thank you once again, ma'am, and we eagerly anticipate the opportunity to host you again. Thank you, ma'am.
thank you so much. Thank you.